Good afternoon.
Okay. Hello. I'm gonna okay, we still have Juan connecting. Okay, Juan is here. I don't know about you guys, I'm rearranging the teams so that I can see them on my screen in the proper order. I'm gonna remove myself, and here are the judges. Okay, judges are here. All right, so before we start the streaming and before we cut this off in the recording, welcome everyone. Today we have one change. One of the judges has to go to federal court on the emergency hearing. So Karen is not here. We have 4 judges. That's your opportunity to have 2 versus 2 hard locked and have them spend like the night arguing who is really the best. Today we do have the swap of the positions from the teams. So whether or not that impacts some of the thinking and everything else. For the rest of this, I think the esteemed judges who, well, they come from 4 different countries, but actually 2 of them banded together to be in the same city for some reason. I don't know why. So I would say that Ryan is like a Canadian, but he's pretending to be a New Yorker.
And I actually live in New York, so I don't know what the issue is with me being.
And then Connie joins from Cologne, and then Anna joins from Warsaw. So we have 4 different regions and 4 different experiences, but everyone is very much into the games industry. And I think that's about any dear teams. Any changes on your side? Like, how will you play it? Will you do it issue by issue or side by side?
Hello, everyone. We have decided to go the entire claimants claims and then the defendants.
Okay, cool. So similarly to the semifinals.
Yeah.
And then, dear judges, if at any point you want to interrupt or no need to raise a hand, just start talking and so on. The time limit includes all the Q&A, so the time is not extended. We have 45-minute limit for the first presentation and then 5 minutes for the rebuttal. It's on the teams to follow the timing, but I will also set the timer and follow the timer as well. And then it's up to the teams how they want to split the time if there are several members of the team. So if there's nothing extra on the side of the teams, then I will ask Mindaugas to start streaming and then hand over to Anna.
Yeah, I'm trying some issues.
You having a Ryan moment?
Everything's okay. For some reason,
Oh, please don't tell me they're going to be called that going forward, Sergey.
He's rebooting YouTube. So yeah, we have some people waiting for the stream.
I don't know how long it will take, so I just say start, and as soon as I fix it, I'll start streaming.
Yeah. Okay. Well, so let's give it, I don't know, 1 more minute.
Chat for 5 more minutes.
5 more. Should be chat. I don't know. Okay, and I think in terms of timing, the teams are more or less in the same time zone, so there's no advantage for one team over the other. In terms of judges, well, I mean, looking at the 2 of them, I think they still have some coffee to go, but yeah, for the rest, they're all fine. So I think we'll just start and then we'll stream
As soon as we can.
when it's rebooted. Okay, so Anna, hand over to you and let the hearing begin.
Okay, thank you. Welcome, everyone. Congratulations for the participants for getting this far. My name is Anna Kabelańska. I'm an advocate. I'm based in Warsaw, Poland. I'm a partner in Kabelańska-Lewaszewski Mednis law firm. My practice has been about 20 years dealing with intellectual property issues and new technologies. And I'm really looking forward to judging this panel. So I wish good luck to everyone. But before we start, please allow me to also present to you or give voice to present themselves to our other judges. Maybe start with Sean.
Sure. Hi, my name is Sean Kane. As I joked around a minute ago, I'm based in New York. I'm the co-chair of Frankfurt Kernit's Interactive Entertainment Group. So basically, I solely handle video game work and have for about 20 years. My background is about half of that time as a litigator and the rest of the time as a transactional attorney. So I've handled many of the type of disputes, both as in negotiations and litigation as what's in front of us today. So maybe pass it on to Connie.
Yeah, thanks, Sean. Hi, I'm Conny Ewald. I'm based in Cologne, Germany, where the famous Gamescom usually takes place in non-COVID times. I've been practicing games law since more than 20 years. I'm heading Osborne Clark's Interactive Entertainment Practice Group, and I also do both litigation as well as contractual work. I very much look forward to today's session. Ryan?
Hi, everyone. Ryan Black. I'm normally from Vancouver, but as joked about earlier, I decided to visit Sean in New York. I'm actually here for, my wife works for an airline and I finally get to travel in this pandemic. And so I was absolutely going to take advantage of it. I work almost exclusively with tech companies and usually internet facing consumer companies. And I am a pure business lawyer. I don't have a litigation bone in my body, although every once in a while my clients do get sued and I have to sit on the sidelines as someone else handles it. But have dealt with some of the issues in this pleading and some of them are very novel to me. So I'm very interested to hear what you all have to say. I believe those are the intros, Anna.
Thank you. Thank you all. As I said before, good luck to everyone. Our fingers are crossed for all of you. And I hope you are ready to start. Maybe start with claimants.
Thank you. Good morning and good afternoon, Your Honors. May it please the tribunal, my name is Abhinav Kumar, present before this learned tribunal on behalf of the claimants. I'm accompanied today by my co-counsels, Mr. Juan Alberto Polito Locke and Mr. Avi Bandari in this matter of Midnight Dive, Penbo, and Fourth Wall. For an overview, I will be pleading on the infringement of copyright claims, while Mr. Polito will be speaking on the defendant's infringing acts by creation of NFTs and the circumvention of Midnight Dive's TPM. Finally, Mr. Bandai will be pleading on the trademark infringement claims, as the inclusion of Penbo's trademarks in orbital decks has no artistic relevance under the two-pronged test laid down in Rogers versus Grimaldi. The claimants submit that the defendant's usage of temporal mirage to extract orbital harbors in-game characters and NPCs and the usage of such game assets in orbital decks is infringement of Midnight Dive's copyrights under section 16(1) of the OCA. We have the following submissions on this matter. Firstly, Briny Brain module is the exclusive copyright of Midnight Dive, and the creation of Temporal Mirage infringes Midnight Dive's exclusive right to create derivative works based on it. Secondly, defendants' use of the game assets and the UGCs to create orbital deck cards amounts to infringement of Midnight Dive's copyrights. Unless the tribunal has any preliminary questions on the facts of the matter, I would like to inform the tribunal that I would be pleading for approximately 15 minutes. Thank you, Your Honors. Firstly, if it may please the tribunal, I would like to begin with the first submission. This submission is outlined in paragraph 13 to 27 of the claimant's memorandum. The claimants submit that Temporal Mirage is a derivative work based on Midnight Dive's copyrights in Briny Brain. It was created substantially based on the proprietary materials and computer codes developed by Ms. Anne Bonney, which materials are solely owned by Midnight Dive. Accordingly, such creation of Temporal Mirage infringes the exclusive rights of Midnight Dive to prepare derivative works based on its intellectual property. The proprietary materials for the module, now known as Briny Brain, were developed by Ms. Bonney on a work for hire basis during her employment with Midnight Dive. This is supported by clause 13.1 of the employment contract, which categorically mentions that all intellectual properties in any works created by Ms. Bonney, which works are incidental to her employment duties and are stored in Midnight Dive's equipment, automatically vest with Midnight Dive upon their creation. Your Honors, the main question of consideration here is whether the creation of the module was within the scope of her duties. To determine the same, we request the tribunal to consider the three factors laid down in US Auto Parts versus Parts Geek, namely, a work is considered within the scope of employment if the work is of such kind that the employee is employed to perform, if it is done substantially within the authorized time and space limits, and if it is actuated at least in part by a purpose to serve the employer. In the present case, all three factors are sufficed by Ms. Bonnie's development of the materials, as Ms. Bonnie was engaged by Midnight Dive as a backend server engineer. She was engaged to specifically support the backend development of the game, and development of software codes and programs were the core of her employment duties. Along with other duties, she was also responsible to identify and solve problems affecting the overall development of the game. Moreover, a game server engineer's role is not just restricted to merely working on the latency and server issues of the game, but includes working with the art designers, providing technical leadership, and acting as a wholesome resource to the developer. Similarly, the findings in Just Met versus Bice, with small game developers like Midnight Dive, employees are generally expected to be versatile and take on different tasks while working independently. Secondly, it is undisputed that the materials were developed by Ms. Bonnie during and after her office hours and were developed using resources, facilities, and equipments made available by Midnight Dive. Lastly, Ms. Bonnie was aware of Titonia's limitations and created the module with the sole purpose to serve Midnight Dive, that is, to improve the character creation and customization tools for the game. This is also supported by the fact that she was part of all internal meetings and groups concerning this issue. Based on this analysis, the development of the materials by Ms. Bonnie, if not part of her primary duties, was at the least incidental to her employment duties and was within the scope of her employment to serve Midnight Dive. We agree that Midnight Dive lacked the knowledge of such development by Ms. Bonnie. However, that does not imply that the module creation was beyond the scope of her employment duties. It is settled in the case of Marvel versus Kirby that the hallmark of work for hire is not the employer's actual knowledge of the creation, but whether it has the requisite power to control or supervise the creator's work, even if it never exercised such power. Additionally, the fact that Ms. Bonnie failed to inform her superiors of such development of the materials is a breach of the employment contract. However, such breach does not and should not preclude Midnight Dive's copyright over the materials and Briny Brain. Thus, we claim that Briny Brain module is exclusively owned by Midnight Dive, and Temple Mirage, being a derivative of Briny Brain, infringes Midnight Dive's copyrights in section 16.1 of the OCA. Unless the tribunal has any questions on the first submission, I would like to move to the second submission.
May I ask one question, please?
Of
Can
course,
you
Your Honor.
explain us what you mean by the inclusion of the work that was done by Ms. Anne on the side of her, standard work, responsibilities, obligations that was then used in the model that she created outside of her employer's company?
Sorry, Your Honor, could you please rephrase the question?
Sure. When you talk about the work that was done on the side of the working obligations of Ms. Anne, you said that this part that she created was the software. Whereas, as I understand, you also claimed that the part that was used by her in the product that she prepared outside of her employer's company was actually piece of work that was, and this is my question, was it software or was it something else in terms of copyrighted works?
Yes, thank you, Your Honor. Sorry, I didn't understand the question before. So the materials used by Ms. Bonnie, the proprietary materials included software codes and the overall idea of creating a module for the character creation and NPC creation, plus customization tools for the game. So these materials were, of course, software codes, source codes, object codes, and other materials in relation to that, based on which Midnight Dive developed Briny Brain, and which materials were handy to Miss Anne Bonnie, which later she developed Temple Mirage based on the source codes to extract characters from the game.
Okay, thank you.
Thank you, Your Honor. Yes, Your Honor.
So you mentioned before that it was pretty clear that she had utilized company assets to create, Briny Brain. And so I guess I was wondering, are you saying that she actually created this using company computers during her employment? And if not, how are you saying that, it was she used company resources or company assets?
Your Honor, can I get a brief moment to refer to my notes?
Sure.
Yes. Thank you, Your Honor. The problem under clarification 7 clarifies that the development of the materials was based on confidential information and Midnight Dive's equipment and resources. So that's where we're basing the fact that when we mention resources and facilities, it would have included the computers, and the fact that all the employees also were aware of Ms. Pony working for a time-consuming project during her employment hours mentions the fact that basically she was also using the computers and other resources available at Midnight Dive.
Okay, can I ask one follow-up then?
Yes.
I understand that that the software was actually located on a flash drive, correct?
External drive, yes.
An external drive. Whose external drive was that?
Your Honor, as per the facts of the case, we do not have the facts that who owned the external drive, but since it was an external, Ms. Anne Bonney copied the software code and the materials to an external drive, and as per the fact she misplaced such external drive in the office of Midnight Dive, gives us the impression that such external drive and other resources were owned by Midnight Dive, and it were part of the resources provided by Midnight Dive. They were just misplaced by Ms. Bonney, but we do not concede that the external drive itself was owned by Ms. Bonney.
Thank you.
Unless the tribunal has any further questions, I would like to move to the second submission. The defendant's usage of game assets to create orbital tech cards amounts to a copyright infringement under Section 16 of the OCA. This submission can be found in paragraphs 49 to 55 of the claimant's memorandum. We submit that the game assets extracted by the defendant and incorporated in the orbital techs are Midnight Dive's original works of authorship. These game assets are protected as graphical and visual works under Section 1.1 of the OCA. It is well settled in the case of Walt Disney Productions versus Air Pirates that visually depicted fictional characters receive independent copyright protection. We agree that Orbital Harbor incorporates various characters and settings from the public domain novel. However, the graphical representation of such characters is distinctive of the characters of the novel itself. This is also supported in the case of Gaiman versus McFarlane, that the graphical representation of a character from a literary work provides distinctiveness to the characters by completing the pictorial features of the character in the reader's mind. Further, Midnight Dive claims copyright solely in the graphical representation of the game assets rather than the character itself. And since these game assets are created using Briny Brain, Midnight Dive is the sole author and owner of all such game assets. Now, as per the facts of the case, the defendant uses the game assets as a canvas or base art to customize them into orbital tech cards. We submit that any such customization by the defendant is mere addition of design to the game assets. And in simpler words, it is a mere reworking of an artistic work into a new artistic style. Such customization by the defendant does not alter or modify the features, attributions, or the essence of the game asset. This is similar to the case of Andy Warhol versus Goldsmith. Now, although we understand, Your Honors, that the cited case is presently sub judice in the Supreme Court, US Supreme Court, the Second Circuit Court in this case has held, and quote, I quote, the imposition of another artist's style on a primary work such that the secondary work remains both recognizably deriving from and retaining the essential elements of the primary work is not enough to be transformative. Thus, it can be said that such cards are substantially created using Midnight Dive's copyright and do not result in original work protected under copyright for the defendant. Additionally, Section 1.4 of the OCA states that copyright over a work employing pre-existing copyrighted materials does not extend to any part of the work in which such materials have been used unlawfully and without authority. Accordingly, we finally submit that the usage of game assets by the defendant in the present case is unlawful and unauthorized exercise of Midnight Dive's exclusive right to create derivative works based on the game assets, and thereby infringes Midnight Dive's copyrights. Unless the tribunal has any questions.
May I have one question?
Of course,
Thank you. Can you clarify whether it is the fourth wall that chooses this artistic work that you mentioned, which is derived from the Midnight Dive game, or do you claim that it's actually the game players that are using this artistic work? I would like to understand whether this is the tool that is provided by the fourth wall, or whether this is the use of artistic work.
Thank you, Anna. As per the facts of the problem, we have on the facts that fourth wall extracts these players using temporal mirage from the game and then customizes such characters by adding its designs and artwork to create orbital deck cards, which are then traded as NFTs on the orbital deck game. So I understand, of course, the players were also extracting players from the game before with the usage of temporal mirage, but these claims of creating derivative works based on or adding customization and using it in a game are against the defendant, as those are solely done by orbital decks on the platform.
Thank you.
Thank you. I would like to move to the third submission then. Even with the player's consent, any use of the game UGCs and orbital decks is infringement of Midnight Dive's copyrights. This submission can be found in paragraphs 57 to 62 of the claimant's memorandum. The orbital harbor UGCs are created by players by customizing the look and appearance of their characters. This is carried out by applying the limited, conditional, and sometimes even time-bound preset features and templates made available by Midnight Dive on the game. For a work to be protected as copyright, the same needs to pass the originality requirement. The European Court of Justice in the case of Payner versus Standard World Lags held that the original creation must result from a free and creative choice of the author, such that the author stamps the work with his or her personal intellectual touch. The UGCs in the current matter, however, do not pass this originality bar, since such creation is bound by the limitations put forward by the game. The player customization choices lack the creative freedom to be eligible for originality and copyright protection for the individual players. Your Honor, these UGCs are derivatives based on the game's original copyright work and are owned exclusively by Midnight Dive. The players do not hold any right to license or permit the use of them without Midnight Dive's express authorization. It should also be noted that the usage of the game is governed by the provisions of the end user license agreement. And Section 5 of the game EULA categorically mentions that the players are not permitted to distribute, transfer, or make any unauthorized use of the game assets in any manner beyond the game or contrary to the terms of the EULA. Thus, the defendant's unauthorized and unlawful use of the UGCs is infringement of Midnight Dive's copyrights. And to conclude, the claimants have submitted that defendant's extraction and incorporation of the game assets in orbital decks is infringement of Midnight Dive's copyrights. Therefore, we request that the tribunal finds such acts of the defendant infringement under Section 16(1) of the OCA, and for the defendant to cease any usage of Midnight Dive's copyrights with immediate effect. Unless the tribunal has any further questions.
I do have a question.
Of course, Your Honor.
Is based on what I've just heard, is it your submission that the efforts that the players may go to select from the tools made available to them just isn't sufficiently original? Is that the idea of what it is you're saying? Because if so, I have a follow-up question.
Could I get a brief moment to recollect my thoughts, Your Honor?
Yes.
Yes. As I mentioned, as per the case of Standard World Lags and Payner, the court refers that any creative efforts of any third party, any party to create an original work needs to come from a free and creative choice to create an intellectual touch to the work. Now, in the current case, while we understand that Midnight Dive is providing multiple choices and customization tools to the players, however, any such customization is still bound by the rules of the game. Since I mentioned the customization options designs might even be sometimes conditional upon reaching a certain milestone or even be time bound, which goes on to say that the player's creative choice is bound by the rules and restrictions put forward by Midnight Dive. And additionally, the game characters and the designs, they're both original works owned by Midnight Dive. Any such arrangement by the players is just by the license that Midnight Dive is providing them to play the game, but does not include any original effort to create any protection under copyright for the individual players.
So I guess my follow-up question would be, I imagine that some players in the game don't spend very much creative effort selecting their various tools in order to create their character, selecting, very generic characters, generic tall, strong character or generic short, stocky character or whatever. But there must be some people within the game who spend quite a bit of time and effort selecting the various tools and resources available to them to make a character that is original. Is there not a possibility that some of the players who make the game are exerting enough creative influence in order to could there not just be a legitimate original use from the various tools available? I mean, I've seen artists do things with just one sticker multiple times that are quite creative. So I just wonder whether is there not an argument that at least some of the use of this would result in original creations of the player?
Thank you, Your Honor. This is a very valid question, and I agree. There are certain games where certain games are open template games where the players can actually have more creative rights in characterization or customization of their characters and the gameplay itself as well. But in this MMORPG game, and with the facts available to us, we submit that the players do not have such liberty to go beyond just the designs that Midnight Dive is providing. So just for example, if we take the example of Player Unknown Battleground, in case there are any designs which are time bound and you can only buy them for 24 hours, you can buy them within the 24 hours and apply them to the characters that the game developer is providing. But you cannot then change or customize those designs that are provided by the developer. It's just creating something, attaching, and which is bound by the rules of and sometimes even when a developer provides you a design, it may just be time bound, and at some point that could be taken away from you as well, which restricts the creative choice of the players. Sorry, Your Honor.
Oh no, I just wanted to ask a quick question. Is it possible to play orbital decks without actually having agreed to the terms of service of Midnight Dive's underlying game?
Sorry, could you just rephrase the question, Your Honor?
Sure. You mentioned before basically that you cited to the terms for Midnight Dive's underlying game, saying that players can't use the items kind of outside of the game, or they don't own them outside of the game. So my question is, is every player that's using Orbital Deck, have they also agreed to the terms of Midnight Dive's underlying game? Or is it possible for them to access it just having agreed to the terms of Orbital Deck?
Thank you, Your Honor. It is very much possible for a player not from Midnight from Orbital Harbor to play Orbital 6 well. But this is just in relation to the UGCs, because the UGCs are extracted by the players and then brought to Orbital decks. Okay, so your argument would be then that particular aspect of Midnight Dive's terms of service would not be applicable to a user of Orbital decks who did not otherwise agree to those terms. Yes, if a player of Orbital Harbor who's not privy to, so someone who's not a player of Orbital Harbor and not part of the EULA is playing Orbital decks without using their UGCs, but just the characters or Orbital deck cards created by Fourth Wall, the terms of the EULA will not be applicable on those players. Yes.
Thank you.
Thank you. Unless the tribunal has any further questions, I realize I'm out of some time as well. I would like to hand over to my co-counsels. Thank you.
Thank you. Good afternoon and good morning. May it please the tribunal. My name is Juan Alberto Pulido Locke, and on behalf of the claimant side, I will address two submissions. First, that the creation and trading of NFTs by the defendant amounts to copyright infringement, as it involves a reproduction and public display of Midnight Dice intellectual property. And second, that the defendant infringed on the provisions of Obligand Copyright Act against trafficking of circumvention technology of a technological protection measure. I will plead for 15 minutes, and unless the tribunal has any preliminary questions, I will turn to my first submission. Thank you. So as explained previously by my co-counsel, Fordwall extracted Orbital Harbor's visual assets to create cards for its own game, creating the derivative works of Midnight Dice copyright. But the defendant further minted these virtual cards as non-fungible tokens, or NFTs, which can be purchased and traded through marketplace platforms. We submit that the creation of these NFTs with Midnight Dice game assets amounts to copyright infringement because it involves an unlawful reproduction and public display of the claimant's copyrighted work. Now, as a starting point, I think I'd like to appraise the tribunal about the technical aspects of NFTs. Your Honors, in very simple terms, an NFT is a digital unit composed of metadata that is stored on a blockchain. Because the code of these tokens is unique, they have become very popular in the market because they allow to represent ownership over different types of digital media assets, including art, music, or videos. And in the gaming industry, NFTs are being used to represent game items or features like the cards in the game of the defendant. Now, while from strict technical perspective, an NFT may be seen as code, it is also true that it exists only to be bound to the underlying asset which it intends to represent. The public buys, trades, and assigns value to NFTs only because of their ability to represent a specific digital asset, and which can be also a copyrighted work, for example, a piece of artwork or a video clip of a movie scene. If an NFT did not represent any asset at all, it would be deemed worthless in the market. Now, the production of NFT using a copyrighted work involves at the very least two of the copyright owner's exclusive rights. First, it involves a reproduction because at the very moment that the user generates an NFT, it is required to upload a copy of the represented assets. For example, if we access the platform of OpenSea and we intend to create an NFT, we will be required to upload a JPG file, for example, in the cases of a picture or a 3D model, or any other kind of media file format that supports a tokenized item. And at that very moment, the creator of the NFT is making a digital copy of the work within an external server in the web. And second, immediately after the creation of the NFT and this copy, the NFT is displayed for trade in the marketplace, and it can be seen by anyone, any user that accesses the platform. If the tribunal allows me, this is an NFT that is available in OpenSea in this moment. This NFT displays the picture of a Pokemon, which can be viewed by any visitor of the website. Now, the key question here should be, shouldn't it be only the copyright owner of this character allowed to create the NFT and undertake these actions of reproduction and display? The answer is yes, it should be the copyright owner. And based on these factors, we submit that minting NFTs with Midnight Dice intellectual property, Fordwall has unlawfully reproduced and displayed our copyright. Therefore, the defendant should be held liable for violation of section 16(1)(a) and (d) of Obligand Copyrights Act. Unless the tribunal has any further question on this submission, I would like to turn to my second claim.
I have a question here. Can you explain us who's actually creating these NFT, these tokens? Are these the game players, or are there any arguments to claim that this is actually the fourth wall that creates these NFTs?
Thank you, Your Honor. Yeah, yes, as provided by the record, there are two kinds of NFTs that are being created. First, there are some NFTs that were created by the users using Temporal Mirage before the existence of Orbital Dex, but after the game came into existence, the defendant started creating NFTs by itself, Fordwall, using the assets that were extracted from Orbital Harbor. This is provided by the record as well.
May I ask a question? The NFT itself does not contain the copyrighted work, though, right? It would just contain a link to somewhere where that JPEG file is stored. Is there anything in the actual NFT that is copyright by your client?
Yes, Your Honor, thank you. That is correct. The NFT itself is composed by code, and itself does not contain a reproduction inside that code of the asset that it intends to represent. It only contains a hyperlink that leads to where the asset is located. But throughout the process of the creation, it is necessary, it cannot be avoided to create this copy. And this is why we hold that the defendant, by creating the NFTs, has made copies in an external server. Now, it should be, I'd like to stress as well that even if the NFT itself does not contain the asset in its code, it is strictly connected to the asset it intends to represent. If an NFT is removed from the marketplaces, the asset underlying that can be a copyrighted work, like in our case, Midnight Dice visual assets, they will stop being traded and being displayed to the public. So therefore, even if the NFT is currently only composed by code, the destruction of the NFTs and removing them from the market will also stop the copyright infringements.
Can you please elaborate a little bit further on why this also means that the copyrighted work is publicly displayed if the NFT only contains code?
Yes, of course, Your Honor. Well, immediately after the NFT is created, it is put for trade into the market, as provided by the record. In the case of the defendant, they are trading the NFT cards through two different ways. One is their own marketplace in their own game, Orbital X, and the second one is third-party marketplaces like OpenSea and Rarible. So at this very at that very moment after the creation of the NFT can be visualized, accessed by anyone, and it is displayed to the public for anyone who intends to trade and buy those NFTs.
Thank you.
Let me ask you one more question. In your opinion, does it change anything that the fourth wall asks the player's consent prior to using player-created characters in NFTs?
Thank you, Your Honor. We believe it does not affect the answer in the sense that the user-generated characters that are extracted from Orbital Harbor and later imported and converted into cards to Orbital Decks would not affect the fact that this is copyright infringement. As was stated by my co-counsel, the players do not have any copyright over the characters, and therefore they should not be able to provide any kind of license to Orbital Decks on the use of those assets.
Thank you.
Thank you. I will then proceed to my second submission. As mentioned by my co-counsel, Temporal Mirage is a software that extracts visual assets from the claimant's game. Now, not only does the defendant use Temporal Mirage, but it also markets, promotes, and encourages players to extract the assets and then later create cards within their own game. We submit that the defendant violates the provision under Section 27(1)(c) of Obliland's Copyright Act, because which bans trafficking in technology that circumvents the protection measure. Specifically because Fordwall is marketing and promoting Temporal Mirage in the market in concert with Bonnie. As a starting point, we'd like to highlight that 3D models and graphics are keystone assets for video game companies. This is why companies like Midnight Dice safeguard these assets with protection measures. And in this case, the company established a scanner that detects and shuts down any background process that may extract the 3D models and graphics that are displayed on screen while the game is running. But despite Midnight Dive's effort, the TPM wasn't duly breached. As we note from the records, Bonnie created and released Temporal Mirage as a tool to bypass our scanner. Temporal Mirage's only purpose in the market is to circumvent the technological protection measure, to detect the game's 3D models that are displayed on screen and later retrieve them into files, therefore providing an unlawful access to the claimant's IP. The scanner cannot be detected by the scanner cannot detect Temporal Mirage only because it was developed by Bonnie using the privileged information of the company while she was an employee. And the way Midnight Dive scanner works actually resembles the findings of the Ninth Circuit in MDY versus Blizzard, where it was held that the scanner that prevents the use of third-party software while playing World of Warcraft was an effective access control measure to the game. Now, the defendant purposely included a feature in their game to allow players to convert Orbital Harbor characters into cards. And to use this option, they must first extract the characters using Anne Bonny's Temporal Mirage. So by establishing this feature, it directly promotes and markets the use of Anne Bonny's Temporal Mirage in the market. Further, Fort Wall is clearly acting in concert with Anne Bonny, not only because she is the founder of the company, but also because they intentionally created a synergy between both softwares, Orbital Dex and Temporal Mirage. And based on these factors, we request a tribunal that the defendant must be held liable for violating Section 27(1)(c) of the Overland Copyright Act. Should the tribunal have any further questions?
I have a question. So is it
Yes.
Is it your position that the scanning software has actually been circumvented because by Anne Bonny and Fourth Wall, or is it that the scanning software, and I mean by circumvent, I mean intentionally circumvented, or is it a situation that the scanning software just doesn't recognize the Anne Bonny's new code as being third-party code?
Thank you, Your Honor. Our position is that it intentionally circumvents the scanner. Actually, as provided by the record, the scanner came into existence when as the game was released, but later Temporal Mirage was released, and at that very moment it started avoiding the scanner. Now, in relation to this, I'd like to highlight the findings of I'd like to highlight the findings of the U.S. District Court of the Northern District of Carolina in Real Networks versus DVD copy control, where it establishes that even if a circumvention, technological protection measure is circumvented, it does not imply that it is ineffective. An access control measure must not necessarily be circumvention proof. It requires only to have some kind of access control provided by the copyright owner. And in this sense, what we argue is that the scanner provided that control with the authority of Midnight Dive.
Thank you.
Thank you. I would like to pass the floor to my co-counsel.
We cannot hear you. It's better now.
Can you hear me now?
Yes.
Yes. Good morning and good afternoon, everyone. May it please the tribunal. My name is Avi Bhandari, and I appear for the claimants in this action. Today, I will be covering the trademark infringement claims as to how the defendant's use of the Benbow trademarks in its digital cards and NFTs constitutes trademark infringement and passing off. Further, I will also explain how the defendant's use fails both the test laid down in Rogers versus Grimaldi, as it has no artistic relevance, and it also explicitly misleads as to the origin of the work, as there is a compelling likelihood of confusion. Unless the tribunal has any preliminary questions, I will commence with my submissions. Now, before I go into the specifics of this issue, I would like to draw the attention of this honorable tribunal to a fact that it is customary for video game companies to develop strategy card games based on their pre-existing titles, taking as reference the in-game characters and the universe that they have created. For instance, Blizzard's card game Hearthstone is based on the characters of World of Warcraft, which is a prior game which Blizzard had developed. Similarly, Riot Games had released Legends of Runeterra, which is a card game again, which is based on the characters of League of Legends. There are plenty of such similar examples. And more importantly, it is the player community which identifies such card games as originating from the same developer. And as far as the facts of the present case are concerned, the defendant has created a strategy card game called Orbital Dex based on the characters of the claimant's game, Orbital Harbor. Now, to increase the interest in the game, Midnight Dive entered into a trademark license agreement with the luxury brand Benbow to introduce branded in-game content. Now, these trademarks are unique, fanciful, and duly registered. The details of the registration can be found in Schedule 1 of Exhibit 1. And these trademarks have also acquired secondary meaning on account of its extensive use for over 30 years. Now, the defendant has incorporated character customizations from Orbital Harbor, which prominently display these Benbow trademarks as part of its cards. And not only that, the defendant is also minting NFTs which prominently display these Benbow trademarks and is marketing those NFTs on marketplaces using Benbow's goodwill. Now, the defendant had recognized the instant popularity gained by the Orbital Harbor game and the immense reputation of the Benbow brand and chose to develop a strategy card game by not taking the time to develop its own intellectual property, but by rather blatantly free riding on the claimant's famous Orbital Harbor game and the goodwill of the Benbow brand. Such usage would have any consumer believe that the defendants are in fact authorized by the claimants, or at the very least, there is a license from Benbow granting the use of its trademarks in the cards and NFTs, when it is actually not. Therefore, we submit that the defendant's use of the Benbow trademarks constitutes trademark infringement under Section 32A of the Lanham Act. It amounts to passing off unfair competition and false designation of origin under Section 43A, and it also further dilutes the Benbow trademarks under 43C. Now, the defendants may try to argue that their First Amendment interest outweighs the claimant's trademark rights on the two-step rule laid down by the Second Circuit in Rogers versus Grimaldi. And to prove so, the defendant must first show that the use of the Benbow trademarks has some artistic relevance to its game. And if the defendant can prove that there is artistic relevance, it must show that the use of these trademarks should not explicitly mislead as to the source. Now, under the first requirement of the Rogers test, the defendants must show some artistic relevance. There have been multiple cases where the courts have considered the artistic relevance of trademarks in video games. For instance, in AM General versus Activision, the court was considering the depiction of Humvee in the famous Call of Duty game. However, the court found that the defendants' use possessed artistic relevance because it evoked a sense of realism and lifelikeness to the players and possessed artistic value to the game. Similarly, in ESS Entertainment versus Rockstar Video, the depiction of the virtual strip club Pigpen was similar to a real-life strip club Playpen, and rightly the court found that it had artistic relevance as the plot of the game allowed the players to experience a gangster culture by developing a cartoon-style parody of East Los Angeles. Now, however, with the facts of the present case, the important question to consider is whether the defendant had any artistic choice towards inclusion of the Benbow trademarks. Did the defendant exercise an option to include the Benbow trademarks? The answer is no, as the incorporation of these trademarks in the cards and NFTs is merely a consequent effect of the extraction of game assets from Orbital Harbor. And therefore, we submit that there is no artistic relevance for inclusion of the Benbow trademarks by the defendant. Now, although we understand that the requirement of artistic relevance has to be more than zero, and if defendant somehow proves that it has that greater than zero artistic requirement as well, which the claimant denied, the second prong of the Rogers test requires that the use of the claimant's trademark should not explicitly mislead as to the source or content of the work. Now, the defendants may argue that they have not made any affirmative statement of the claimant's sponsorship or endorsement, but we submit that it is not a rigid requirement that it has to be explicitly misleading. It was confirmed in the case of Gordon versus Drape Creative, where the court held that affirmative statement is not a prerequisite. In fact, the use of the mark alone may explicitly mislead consumers about a product's source if the consumers would ordinarily identify the source by mark itself. Therefore, we submit that the explicitly misleading element of the Rogers test, which is similar to the ultimate likelihood of confusion test in ordinary infringement cases. And in assessing the likelihood of confusion, the courts generally follow the multi-factor test laid down in Polaroid versus Polaroid. Now, our specific submissions in relation to each of these factors can be found at paragraph 67 to 81 of the claimant's memo. Most of these factors under the Polaroid test are in favor of the claimants. Now, with regards to the first and the second factor, which consider the strength of the claimant's trademark and the degree of similarity of the parties' mark, we submit that Benbow has acquired powerful trademark rights on account of its extensive use and registrations. And it is a settled position that the Benbow trademarks have been reproduced on the cards and NFTs in their entirety. Now, with regards to the third and fourth factor, which consider the proximity of the competing parties' goods and the possibility whether the claimant will bridge the gap. In this regard, we have two submissions. First, The claimants use the Benbow trademarks in relation to video game and in-game assets prior to the defendant. And secondly, the defendants cannot argue that the claimant has not used the Benbow trademarks in relation to NFTs, as bridging the gap is possible in this case. Your Honors, NFTs have become an exciting way for brands to interact with their consumers, and they have quickly become pervasive in their use by brand owners who are seeking to enter this nascent marketplace. In fact, many prominent apparel and consumer brands have recently incorporated their trademarks in NFT collections, such as RTFKT has collaborated with Nike to bring their own NFT collection, similarly Dolce and Gabbana, and so many more. And brands have also started protecting their intellectual properties by filing appropriate applications in Class 9 or Class 42. Now, the pivotal question to be looked here is not whether Benbow will actually enter in the NFT industry, but it is rather the consumer perception that whether Benbow is likely to enter into the NFT marketplace. And any consumer who would see these NFTs which bear the Benbow trademarks, they would assume that Benbow has now entered into the NFT industry. Now, Your Honors, with regards to one more factor, which is one of the most relevant factors under the poll, right? It is the bad faith of the defendants which must be seen. Now, the defendants have adopted a game title, which is Orbital Dex. It has a similar meaning as to that of the claimant's game, which is Orbital Harbor. They have also adopted an in-game currency called D-Bloon, which is similar to the claimant's in-game currency called Doubloon. The entire business model of the defendant's game is actually based on unlawfully extracting game assets from the claimant's game. So if any unsuspecting consumer is likely to believe that Orbital Dex, which has a similar game title and currency as Orbital Harbor, uses characters from Orbital Harbor and also displays these Benbow trademarks, they would assume that this game is originating from Midnight Dive, and at the very least, there exists some connection between the two games. Therefore, we submit that the Polaroid factors weigh in favor of the claimant, and there is a compelling likelihood of confusion. Your Honors, what I would also submit is that the defendant's use of the Benbow trademarks has diluted their distinctive quality and has also tarnished their fame by undermining and damaging the goodwill associated with the Benbow trademarks. Your Honors, I think we're finished on time, but may I request 2 additional minutes?
It's okay on my side, but I'm looking at the rest of the judges. Okay.
Thank you. Now, with regards to dilution, we submit that Benbow has no control over these NFTs as to how these NFTs are traded, how they are sold or redeemed by the players. And upon seeing these cards and NFTs, any consumer will believe that these Benbow has expanded to the NFT industry. If there's any fraud or any illegal activity in relation to these NFTs which bear the Benbow trademark, it would be ultimately Benbow's goodwill and reputation which would be damaged. And since Benbow has no control in case of these cards and NFTs, there is a very high likelihood that consumers will assume that it's the Benbow's brand which is endorsing these NFTs. So to conclude my claim, I would submit that the Defendants Act have created a likelihood of injury to the claimant's business and reputation by adopting Benbow trademarks and by adopting a deceptively similar game title and in-game currency. And therefore, it constitutes trademark infringement, passing off, and unfair competition by creating a likelihood of consumer confusion, mistake, and deception as to the source of the Orbital Dex game. If I can be of any further assistance to this Honorable Tribunal, claimants conclude their arguments.
Yes, I have a question. Does the Benbow license to the claimant specifically allow for the claimant to bring litigation against an infringer?
May I request a brief moment to have a look at my notes?
Sure.
Your Honor, Benbow has not assigned any specific rights to Midnight Dive to pursue infringers, but Benbow is actually a part of this litigation as well. So the claimants are Midnight Dive and Benbow both.
Thank you.
I have one question. I'd like to ask you about this claim that relates to trademarks. As we understand, trademarks are registered in relation to certain goods or services. We understand that Benbow also registered its trademarks in relation to certain goods. Can you explain us, when you claim that there might be infringement of trademarks of Benbow's, in relation to what kind of goods we have this infringement when these assets are used in the video card game?
Thank you, Your Honor. Your Honor, in relation to this, I have 3 submissions to make. First, an unregistered trademark infringement claim can be sustained under Section 43A of the Lanham Act. To prove infringement of an unregistered trademark, the claimant must show the 3 elements which are required for infringement of registered trademark. It must have an interest in protecting a trademark. The use of the claimant has to be prior to the defendant's use. And thirdly, such use leads to confusion in the marketplace. Now, even though Benbow does not have any registrations, it can still assert its rights because it has common law rights, and these arise automatically from using the trademark in commerce. Benbow has used these trademarks in relation to digital assets as part of a video game, and the defendant has used them in its video game, a strategy card video game, as its cards as well as NFTs.
Thank you.
I'd like to ask a question about the customer confusion. You'd mentioned earlier that the names of currencies and other things in the game were similar, but I have to admit, and this is maybe just my own personal thing, but when I see a product that has names that are similar but not the same, if someone in a movie pulls out a Mooster card instead of a MasterCard, I kind of assume that they don't have the license. I assume that it's not a related party. And I don't think that it originates from the person, because had they done that, they would have actually used the proper name. Do you not think that there's a little bit of a kind of tongue-in-cheek ability for a party to parodize or satirize an existing brand by naming it something similar, so that it seems like a real world, but it's obviously not using the original property?
Thank you, Your Honor. Your Honor, in this regard, I would first submit regarding the in-game currency, which is used as called doubloon. Doubloon is actually it's an annotation to a currency which is used by the pirates. There are other currencies as well which were used by the pirates, which is called like pieces of 8 is one of the examples. Now, in this case, I'm not claiming trademark rights in doubloon. What we are trying to submit is that the defendants have used these trademarks as the game title is Orbital Decks and Orbital Harbor. They've used in-game currency. The claimant's in-game currency is doubloon. They have used doubloon. And they have also extracted the characters which display Benbow trademark. As in context of all of this, what we would submit is that defendants is trying to pass off their game as to show that there is some affiliation between Orbital Harbor and Orbital Decks, because the player community also identifies such card games, as I had explained in the example of Hearthstone and World of Warcraft, or Legends of Runeterra versus League of Legends. So it's the defendant's intention to pass off this game as to it has some affiliation or connection with the claimants. And further, I would just like to make one more point. There is no artistic requirement for the use of a luxury brand for a game which is based on pirates in space. So I would not see a pirate wearing a Benbow branded bag. That is something, there's no artistic relevance in seeing that.
Thank you. Okay. I understand that you have concluded your pleading. Is the other counselor ready to go?
Yes, Your Honor.
Okay, so you can start then. Thank you.
Thank you. Good morning and good afternoon to all of you. My name is Laura Barrera Cano, and I will act on behalf of Fourth Wall, the respondent in this action. I will be presenting several submissions in response to the claimant's claims regarding the assets from Orbital Harbor and Benbow's trademark, the use of temporal mirrage, and the trading of NFTs. For a better understanding of the response, I will tackle the issue in another order than the claimant. I will be speaking approximately 40 to 45 minutes in total and give all of the respondent submissions. If I may now turn to the first claim regarding the extraction and use of Orbital Harbor in-game assets and Benbow's trademark. I will be speaking for approximately 20 minutes. The arguments can be found in pages 8 to 17 of the respondent's memorandum. First, regarding the acquisition of extraction and use of Orbital Harbor in-game assets. According to Article 6 of the Oberland Copyright Act, the author is the employer when the task is done by an employee in the course of their job, which is consistent with the work made for hire doctrine. I will be tackling thus first the temporal mirage tool and the creation of Brainy Brain module. Some criteria needs to be met in this case. It either falls within the scope of employment or the work must fall within one of the 9 categories of work listed in the work for hire doctrine. First of all, in this case, the facts never specify if the external drive where all the preparatory materials were stored is the company's material. The claimant also fails to prove it. Midnight's Dive only knew of the work because of an external audit. Moreover, Anne was hired as a server engineer, and even if her tasks included the maintenance of the server and identification of issues, it did not include the development of new features to improve the game experience or taking into consideration the design of the game and creativity. The missions delivered were solely security-oriented to develop and maintain the servers or even ensure low latency. Any interactions with designers and other teams is to make sure the game server and the game runs correctly. Ping, latency check if the graphics don't consume too much energy. It's never specified that it's to improve the user experience when playing the game. It's simply so that they can correctly play the game. In addition, none of our employers knew the extent and content of our project, nor did they give the task as Anne Money was not working on the tool while being subject to direction. Moreover, she didn't report the work when being fired. It's not a breach of contract if it doesn't meet the criteria and it was not stored in company equipment, nor meant to be for Midnight Dive's use. Otherwise, she would have mentioned it in order to avoid getting fired in the first place. Secondly, computer software doesn't fit within any of the 9 works category because it's considered a literally work. I would also like to remind the court that the content inside the drive is indeed a repository along with the source code, documentation, and preparatory materials for the module. So it should be considered literally work by definition. Both Temporal Mirage and Brainy Brain have the same basis, but both needed more development upon the preparatory material before being able to be used. The Brainy Brain module has to be considered illicit derivative work, and copyright on its code source, as well as the assets generated, if considered copyrightable, can only be given to the claimants to the extent of their addition to the existing work of Anne Bonny. I would also like to state that Fourth Wall never mentions Temporal Mirage in its ULA, nor directs users to that tool. If I can then move forward to the second point, where the claimants fails to prove ownership of copyright over the assets generated by the Brainy Brain module. Even if the claimant could be given by the court copyrights over the additional code source of the Brainy Brain module and the assets generated to the extent of their additional work, the assets generated do not meet the copyright requirements. There are 3 basic requirements for copyright protection. It must be a work of human authorship, it must be original and fixed in a tangible medium of expression. The claimants failed to prove the reunion of all these 3 requirements. Orbital Arbor was developed with Trisonia, the in-house game engine, and set in the fictional universe of Treasure Island, a public domain novel. Orbital Arbor used the novel and the story to create the game. The claimants failed to prove that their appropriation of a public domain work can be considered original, since the work is not independently created by the author, but based on a novel. Simply stating that the background is different doesn't prove that it's transformative enough to gain copyright. Instead of being pirates in the sea, it's the same in space. In the Gorski case, the court found that a plaintiff's complaint made with only conclusory statements that their characters are distinctive failed to meet the burden of alleging with sufficient detail copyright ownership. The claimant merely explains that the type of content they mention can be copyrightable, giving court examples without explicitly giving the reasons why its allegedly owned content should be considered original. In addition, the claimants cannot claim copyright over the public domain work, which means that the elements that were clearly kept from the novel cannot be subject of copyright. It is
Excuse me, may I interrupt you here?
Yes.
I'd like to understand it and maybe elaborate on that further. You say that we have here a book which is in public domain name, which is not, as I understand, protected by copyrights anymore. And then we have characters which are created for the purpose of a video game, which, as I understand, are kind of not literary works, but more like artistic works. And then you say that they cannot be copyright protected because they were based on something that is in public domain. Is my understanding correct, or am I wrong?
My arguments are based on two different cases. The assets that are based on the novel, so they can only gain copyrights for the additional things that are different from the public novel because it's a public domain. And then it's on the Brini Brain module and the assets generated by the Brini Brain module.
So maybe just one more additional question. Do you say that if we have something that is based on work that is already in public domain, then anything created on the basis of it, like let's say derivative works, cannot be copyright protected?
No, what I was arguing is that I can also take the work from the public domain novel and create pirates in the space because it's a public domain novel. So, which means that the characters they create based on the public domain novel must be original and have sufficient originality to be copyrighted. But I can also take that novel and create pirates in space based on the public domain novel.
Okay, and the characters that were used in both games and that were actually somehow based on Treasure Island, they, as I understand from what you say, they were based on something that does not allow them to be copyright protected because this is already in the public domain.
This is for some of the assets, which are the basis of the game. But then the assets that are the subject of this infringement accusation are the ones generated by the Brini Brain module.
Okay, thank you.
Thank you. So regarding the assets that are subject in this copyright infringement claim, it's the NPC generated by the Brini Brain module, the avatars created by the users using the tools put in place by the Brini Brain module, and the in-game assets generated by the Brini Brain module. Regarding NPCs, they are randomly created and should be considered stock characters that cannot be protected since no description has been given by the claimant to prove there are no general traits and similarities between them. They are generated by the Brini Brain module automatically, which is a computer program that procedurally generates content. Let me quote, a module that could procedurally generate environments. Procedural generation is a method of creating data algorithmically and not manually. And the copyright law only protects the fruits of intellectual labor that are founded in the creative powers of the mind. There must be human authorship. Are created by an algorithm can be copyrighted if there's no human interaction into the final work. Plus, the claimants don't justify to what extent the procedurally generated content can be copyrighted. They only give statements without actual justifications. Regarding the avatars created by the users, even if they are created through the tool provided by Midnight Dive, they are created by selecting among a set of game-provided attributes, but the final result is the work of the user that selected and aesthetically arranged its avatar. The user invests time and creativity in creating and customizing an avatar. Here, contrary to the NPCs and assets, the module allows human interaction through the users in the generation of the avatar.
I'm sorry, may I ask a question?
Yes.
You know, you're saying that basically if a user is using kind of tools that exist within a game, what they create is not owned by the game company. Is that what you're saying?
What I'm arguing is that in this case, since the tools provided to the user are based on the Brini Brain module that was not that should not be considered human authorship, then the users creating the avatars are bringing that human authorship, and in this case they should be considered either the original creators of the avatars, or if then copyrights is given to Midnight Dive, at least joint authors and derivative work.
So then you're saying if the panel finds that Briny Brain is owned by the claimant, then you're admitting all of these things that are being created by the users would be infringing, correct?
Well, it will not be on the arguments that the Briny Brain module is owned by the claimants, but rather if the work that the Briny Brain modules create can be the subject of copyright, not the tool itself.
But again, I guess I'm not understanding your argument, because it sounded like a minute ago you were saying because Briny Brain was created by the respondent, and the tools that exist there are tools that your respondent claims to own, they would have the right to allow users to use these tools to create whatever they would want, and that wouldn't be infringing of the underlying rights in the game. Am I mistaken?
And we argue that Anne Bonny is the author of the preparatory material that served to create the Briny Brain module. And if she's not considered to be the owner of the Briny Brain, the preparatory material to use to create the Briny Brain module, then there will be two different scenarios. If the Briny Brain module is hers, then in any case, there won't be a problem of copyright because the users are using a tool that was put in online by.
I understand that position. I understand.
Okay.
What is your second position then?
And then the second position is that if the Briny Brain module is owned by Midnight Dive, they did not sufficiently prove that the assets created by the Briny Brain procedurally can be the subject of copyright. Thus, if there's no human authorship in the assets created, and that human authorship can only be found in the actions of the players, then they are the ones that can own copyrights over the avatars.
How does that play out with the the MicroStar FormGen case, where the court found that user-created levels were actually derivative works owned by the underlying developer and not the users or a third party that was actually selling those levels?
Well, in this case, the main argument is on the procedural generation, because if the assets are created procedurally, then Midnight Dive doesn't have copyrights over them, so I can use them. It's like having a tool that allows me to select different types of hair for my avatar, but the person that put that tool in place does not have the copyrights over the hair put in place because it was created procedurally.
Okay, so then things that are not created procedurally, are we going back to, as I said a moment ago, if there's something that is actually not being created procedurally, but Briny Brain is owned by the claimant and individuals use it to create something new, would you agree then those are derivative works that would be owned by, by the claimant?
Well, in that scenario, I would agree that it's the player still that owns the copyright, but it's not the subject of here at the court, because it's the asset generated by the Briny Brain module that are accused of copyright infringement by extraction and reproduction.
Okay, thank you.
Thank you. So I will then move on directly to the in-games generated by the Briny Brain module. These are assets generated by the Briny Brain. They are the only ones the temporal mirrorage tool can extract. And the same arguments as the one presented for the NPCs apply to these assets, they are procedurally generated too, which mean unless their originality and creativity is proven by human interaction, they can also not be the subject of copyright. The claimant should have pleaded their originalities and not only argue that they are not under the exception. And the Supreme Court in the Portola case has already made clear that a copyright plaintiff bears the burden of proving infringement. I will continue if the court still considers Midnight Dive assets to be copyrighted. Fourth Wall did not infringe any rights, because in this case, there's two different actions to be separated: the extraction of the assets and the input in the Orbital Dex game to form a new work. Both of these actions are, by the way, conducted by the users themselves when using Orbital Deck, and Fourth Wall asks for user consent when creating the NFTs. Should a person be a direct infringer of extraction, it's the users. Indeed, regarding the extraction, it is made by Orbital Arbor users to then create the NFTs or simply showcase their avatars in forums. Orbital Dex never mentioned temporal mirage in its ULA, thus never forcing or leading the users toward that tool. Orbital Dex ULA clearly states that the creation of the NFT doesn't give copyrights over the embodied content. It is also important to mention that Midnight Dive was aware the players were extracting and converting the assets in NFTs, but never took action at that time, giving an implicit right to do so if the court considers they are the subject of copyright. This implicit right is not only on the extraction, but the NFT creation, as the players already traded NFTs on OpenSea and Rarible before the launch of Fourth Wall. Finally, the claimant attacks on direct infringement and not contributory infringement. We cannot be considered responsible for the player community actions as a whole. I will now move to the Benbow's trademark accusations. I will only address Fourth Wall use in the cards, not the players' community actions as a whole again. Infringement, the claimant must have shown that the mark is legally protectable and owned by the plaintiff, and the defendant's use of the mark is likely to create confusion concerning the origin of the goods and services. Regarding the scope of protection of a trademark, it is not registered in Class 38, telecommunication, neither Class 41, entertainment, nor Class 28, games, but in Class 16, 18, 24, 25. The given classes are the only ones that would apply in this scenario in virtual worlds. If they wanted trademark protection, they needed to register the trademark in the corresponding class, like Nike and other brands are doing. Otherwise, they can perfectly coexist. Regarding Benbow's license agreement, it is only concluded with Midnight Dive, not Fourth Wall. It should then not be enforceable against a third party. Moreover, the use of a trademark in an artistic work is actionable if it doesn't mislead as to the source or content of the work. A whole set of factors was determined by the court to assess in the Polaroid case. In this case, it doesn't mislead. The players know where the mark and assets come from, as they are actually the ones executing the extraction and input action in Orbital Dex. Then Orbital Dex asks for user consent and creates NFTs. Plus, the games are completely different, as one is an MMORPG and the other is a card trading game. The products cannot be considered of close proximity. If we come back to the examples of League of Legends and World of Warcraft, the card games were primarily launched for fun games audience, not PC audience, even if we can play now with the computer, which is not the case here. In this case, the games are not under the same launcher also. When you play World of Warcraft and Hearthstone, you have to go through the same launcher, so you assume it's the same creator for both games. We never mentioned Orbital Harbor nor Temporal Mirage. The games have orbital in common, but it's pretty common in video games in space, like the term world of cannot be only used in Monopoly by World of Warcraft, but World of Tank, World of War, etc. Doubloon is the ancient Spanish gold coin. It will be like explicitly stating that when a game uses gold coins, they cannot use the term gold coins, like Minecraft, World of Warcraft, Iron, even League of Legends. In addition, Benbow's trademark only appears because it's attached to the avatars and the game characters, not to explicitly reproduce the trademark for commercial use, proving good faith in its partial reproduction. In that sense, users cannot be mistaken, like argued by the claimants. It's not intentional nor predominant, and it doesn't explicitly mislead as to the source or content of the work. So the use of Benbow trademark should be allowed, and it does not constitute an act of unfair competition.
Excuse me, may I interrupt you here?
Yes.
I have a question. Listening to your arguments, is your argument that when we have the same characters into different type of video games, video game, and a different type of video game, then we should think that the users, the players of these two games will not be misled, even though the characters are exactly the same in both video games?
Thank you for your question, Your Honor. In this case, the characters are not the same. Indeed, when it's World of Warcraft and Hearthstone, it's exactly the same characters that are used in the cards game. Here, we use the characters that the users created as a canvas, and then we had a whole lot of differences to that. We had statistics, we modified the artwork, so it's not the same character as the one you can find in the game Orbital Harbor in the end.
So what would be then the reason to take these assets from one game and implement them into the other game if this is something completely different or something completely changed?
Well, it's since NFT trading is becoming more popular, then the players want to use their characters and put them in the cards game. It's just that we allow that, and in order to do it legally and in good faith, we modify the input from the users, and also to show that it's not the same game, that we are a completely different game.
So on one hand, we have players who want to have their characters from the game that they play and they like in another game. But on the other hand, you say that the company is changing these characters in a way to avoid the claim of copyright infringement. But I understand that this change means creation of a derivative work. Is that your argument, or am I wrong?
Yes, it's derivative work in the sense that it's completely different, substantially different from the input of the characters to create the game. It's like using the picture of a cat as a canvas, and then I create a card and I create a character that has a tail and ears. And I use the picture of the cat, but then it's completely different in the end.
And the use of derivative works, doesn't it mean that the user should first have the allowance of the copyright holder?
In that sense, we do not enter into the relationship of the player with the previous game. We are also not limited to Orbital Harbor. There's nothing in the ULEZ that indicates that we will only be using assets from Orbital Harbor, and we make sure that when the players put the artwork, they comply with the ULEZ. They agreed that they cannot modify the art inside, and we do not give any rights for the art. We only give ownership of the NFT.
Thank you.
Thank you. And then that concludes my response for the first submission. If I may now turn to the second claim regarding the circumvention of Minat-Dive technological protection measures, I will be speaking for approximately 10 minutes. The arguments for this first claim can be found in pages 17 to 20 of the respondent's memorandum. Regarding temporal mirage copyrights, as stated in the first response, Anne-Bonny has to be considered the owner of the copyright over the preparatory material. Temporal mirage is thus a creation. Temporal mirage was released by Anne-Bonny, not Fourth Wall, as Fourth Wall did not even exist at that time, but we will nevertheless address the circumvention accusations. Arguments in this part will tackle the other criteria in the case the court still considers the work to be copyrighted, because in order to have circumvention, you need to have copyrighted work. In order to prove that a technology circumvents a technological protection measures, several things has to be considered simultaneously. Indeed, the presence of a copyrighted work, the acting without authorization, the presence of a technological measure and control access, and finally, a circumvention. A technological protection measure is a device or software placed on copyright material to prevent unauthorized access or copying. The scanner should not be considered by the court as a sufficient technological measure preventing access or copying. Indeed, the scanner only detects, it doesn't prevent any extraction. Moreover, the players have access to the game assets when playing Orbital Arbor. They need to have an account, enter, use the extraction tool, which means the technological measures in the shape of an account registration is never bypassed. Another point to consider for the circumvention criteria is that the temporal mirage tool is never mentioned to be used only in Orbital Arbor. The game Orbital Dex never mentions, again, Orbital Arbor in its ULA nor temporal mirage. It's never directly marketed by Fourth Wall, and there is no profits over direct use of the tool. We can then consider that the purpose and character of the use of temporal mirage is only for non-profit educational purposes without the commercial nature behind, and not to specifically circumvent a technological measure. The criteria are thus not met. Further proof supporting this argument is the fact that the temporal mirage tool was released under a general public license. The general public license is a form of copyleft intended to assure everyone the effective freedom to copy and redistribute it, with or without modification, either commercially or non-commercially. The tool was created as a new idea to allow fair access, and even created before the launch of Fourth Wall and Orbital Dex, and distributed publicly without asking for remuneration for its use, proving good faith in its distribution. The tool allows it to extract assets, but only a certain type at a given time. So it also falls under the minimis taking doctrine, where the amount copied or accessed is so small, it can be considered a fair use and insignificant. The tool allows modding, which is common in video games. The modding community has met with acceptance this type of use. Should the court consider the claimant's arguments that Orbital Dex and Orbital Arbor are similar, I would like to recall that Valve Corporation games, Counter-Strike, Team Fortress, and Day of Defeat all started as third-party mods before becoming full games. It is indeed common in the video games industry to use extraction tools to create mod or content. To conclude on the accusations of circumvention, the court should thus state that the claimants did not sufficiently prove a technological measure protects against extraction, consider that the purpose and character of the use of temporal mirage is for non-profit educational purposes without the commercial nature behind. Should circumvention still be retained, it falls under the minimis taking doctrine. If there are no questions, Your Honor, I will now turn to the last claim regarding the NFT trading operations. I will be speaking for approximately 10 to 15 minutes, depending on the time that I have left. The arguments for this first claim can be found in pages 20 to 24 of the respondent memorandum. I will be mentioning two important points regarding Fourth Wall game Orbital Dex, not the players, because again, we are not responsible for the player community as a whole. Copyrights over the file linked to the NFT and ownership of the NFT itself and its trading. First of all, regarding the NFT trading operation claims, it's important to remember that it's the final avatar customized in the game by the player that is being used to create the NFT as a canvas, not the in-game assets separately. As indicated in the MicroStar case and that we discussed, to prove infringement, the party must show that the works are substantially similar, something the claimants did not prove. This part is to be considered jointly with the defense on the copyright infringement, since the elements that cannot be subject to copyright, as explained, public domain, created procedurally, scène à faire, functional elements, have to be excluded from the test. In deciding whether the art embodied in the NFT is substantially similar to constitute a copyright infringement by creation of unauthorized derivative work, the widely used two-part test should be applied. the existence of substantial similarity under both the extrinsic test and the intrinsic test should be established. The intrinsic test focuses more on general impression, look and feel, while the extrinsic test, focuses on the objective comparison of comparable elements. As already stated, Fourth Wall is a different type of game, cards game. They add their own artistic creation to create and generate the final unique art with a different style, which means the final outcome is substantially different from the input of the player. The essence is changed. Fourth Wall creates the in-game skills, ability, and stats for the games and actively balances the game based on gameplay data and a formula they developed, which shows the creativity and energy being put into the making of the cards.
Can I ask a question of you? Just going back to the to your discussion about infringement, that the claimant would have to prove that they are substantially similar. Isn't a character that is extracted from a game that clearly resembles the character in the game, that clearly has the same features and traits as the character in the game, is that not kind of just by the fact of its existence substantially similar?
Well, yes, in this case, there are two types of actions that could be considered when the players extract the assets and use them in forums and to mint NFTs. But the Midnight Dive completely authorized that use because they never any action against the players. And then in our case, what we do is just have the consent from the players and then create the cards, and we change the content because we only use the input from the players as a canvas. So it's substantially different, since the final product we are sharing and that is embodied in the NFT is not the sole extraction of the player character.
Thank you.
Sorry, maybe I missed that point. You've just spoken about the authorization. Where do you see the authorization in not acting, or what was the point here?
We asked consent. It was in the clarifications, if I remember correctly, of the problem. Mm-hmm. It was said that we ask users' consent before modifying and adding our work in the input, and then they receive the final card.
Thank you.
But I understand that this only relates to assets created by the players. What about the authorization from the authors of the original work, of the original game, and non-player characters?
Well, as stated in the first part, non-player characters should not be the subject of copyright because they are created procedurally by Brainy Brain, and the claimants did not give any information in how they have human authorship, and that condition is met. And moreover, again, it's not Fourth Wall that extracts and inputs the player characters or NPC in the game, it's the users themselves.
Okay, thank you.
Thank you. If there is no further question, I will continue on the NFT trading. Fourth Wall creates the in-game skills and abilities and stats for the cards and actively balances the game based on a gameplay data and a formula they developed. Usually video games that create a card game use the extracted same characters as we discussed. Here it's not the case. I will now move on with the NFT themselves. They are owned by the users. So this is more on the ownership concept and not on the copyright concept. Fourth Wall allows users to mint and trade the characters as NFTs on OpenSea and Rarible, which is actually an action already conducted by the players before the creation of orbital decks. So it's nothing new that Midnight Ave was not aware of. An NFT, as the claimant explained, is a record of ownership of an asset, which means the emphasis is on ownership, seen as a question of virtual property rather than copyright. It should be considered like a format, a container. Minting an NFT doesn't give the player rights over the eventual copyrighted work underneath, just over the container. The mechanism can be compared to buying a t-shirt with a copyrighted character on it. The character is printed on the t-shirt, but the person owns the t-shirt, not the copyrights over the character. Before installing and accessing orbital decks, players must agree to the EULA, and as already mentioned, fourth wall also asks players' consent prior to using player-created characters. Plus, fourth wall EULA 0.6 clearly states that ownership of the NFT does not grant ownership of or any other rights with respect to the content and art embodied in the NFTs. The users are asked not to modify the art embodied. Let me quote, "You agree that you may not nor permit any third party to do or attempt to do any of the foregoing, modify the content and art embodied in the purchased NFT in any way." They are also asked not to use the content except for a personal non-commercial use. Again, the emphasis is thus on the concept of ownership. The EULA tries to differentiate the copyright part and the property detached from copyright in line with the Obliland Copyright Act, Article 6.5, let me quote, "Transfer of ownership of any material or digital object does not itself convey any rights in the copyrighted work embodied in the object." We could own an NFT without transferring the copyright to the underlying piece of art. This also means that even if fourth wall receives a commission fee, the fee is on the ownership transaction of the NFT, not on a copyright basis. Moreover, regarding the trademarked assets from Benbow, the agreement is between Orbital Arbor and Benbow. As already stated, Benbow only protected the mark for certain types of use, which does not include the audiovisual work. In addition, regarding Benbow's trademark specifically, the claimants failed to prove that the use of the mark in the NFTs could ultimately preempt Benbow's ability to offer products and services in virtual marketplaces. Benbow can perfectly create its own NFT that is separated from, not worn by the avatars. Indeed, the mark is only present in the NFTs because the avatars wears it. It's not considered a pure and simple reproduction of the mark. We are far from the 2022 Birkin bags case being currently judged by the US court, well, where the whole bag is reproduced and the name used is Meta Birkins. Finally, it's important to mention that if the court considers the users to have copyright over their avatar, they can perfectly create and own an NFT. In this scenario, not only will they have the ownership of the NFT, but also the copyrights attached to the art embodied, if these are the NFTs created outside Orbital Deck. Fair use should also be considered to allow innovation. If the court still considered the creation of NFTs as being copyright infringement, indeed, fair use exception should be considered. To consider fair use, the purpose of the use, the nature of the use, and whether it's commercial in nature, how the use affects the potential market for value of a copyrighted work, and the amount and substantiability of the portion used in relation to the copyrighted work as a whole should be taken into consideration. In this current situation, the final result is considerably changed, as already demonstrated in the pleading. It should be considered transformative enough by the court to qualify for fair use. Moreover, the use of copyrighted material is not for commercial purposes. We can sell and sell the NFT, not the art embodied in the NFT. Selling the NFT does not give the buyer any particular rights at all. The users are asked, again, not to use the content. Prohibiting the creation of these NFTs will be blocking creativity and innovation in a rising sphere. To conclude, Forthwell asks the court not to cease all NFT trading operations and not to give accounting of any and all sales related to Orbital DEG. Forthwell did not profit from conscious wrongdoing of any kind. Forthwell did not infringe any copyright and trademark as argued in the first part. As the claimants essentially failed to prove the existence of intellectual property rights, copyrights are to be differentiated with ownership of an asset, a virtual object, including an NFT, and Orbital DEX players are to be considered by the court owners of the NFT, regardless of the copyright of the art embodied in it. That concludes my response. Thank you, Your Honor, unless you have any question.
I have a question. So when did your client learn of claimants' use of Briny Brain in their underlying game?
I cannot actually give a precise answer because it was not given in the facts. We only know from the facts that the game Orbital DEX was released 4 or 5 months after the use of the Briny Brain module, and I guess it's because it was a huge thing in the community.
But so your client's game, though, obviously your client knew that Briny Brains was being used in the underlying game, because otherwise there would have been no game, no Orbital DEX for your client to develop, correct?
Well, my client knows that for now, the assets from Orbital Arbor can be used in Orbital DEX, but there's nothing from the facts that impeaches the use of assets extracted for any other game.
Okay, thank you.
Thank you.
Okay, if there are no further questions on the side of judges, thank you very much. We now have time for to present your rebuttal, if both sides are willing to do so. On the side of the claimants, who'd be presenting the rebuttal?
With the permission of the tribunal. With the permission of the tribunal, I would like to seek permission to take rebuttal on the defendant's claims one by one and separately by each counsel. On the copyright claims, first of all, the defendant claims that Forthwell does not extract any characters from or other assets from Orbital Harbor. This is against the facts of the case, and this is actually provided in the second paragraph of the first page of the problem, where Forthwell, a game development studio, used a software tool to extract characters and other assets, including Benbow branded items from the Orbital Harbor. Secondly, the defendant alleges that Anne Bonny's engagement was not a work for hire basis engagement. However, to determine the same, the court in Community Creative Nonviolence versus Reed followed 11 factors, and additionally, whether the employer had control over the employee, which we've already in our pleadings determined that the control is not towards the actual knowledge, but whether they had the actual control or right to supervise such creation, even if they don't exercise such rights. Additionally, accordingly, however, we don't have this. We don't have the facts to cover all the CCNV factors in favor of the work for hire basis arrangement. However, majority of the factors in CCNV do follow the inquiry that her engagement was on a work for hire basis. Secondly, as rightly mentioned by the defendant, for a work to be copyright, it does need to be original. It needs to be fixed in a medium and be of a human authorship. As pleaded in our claimant's pleadings, we already determined that the claimants only claimed a copyright in the graphical representation of the characters. While we're not claiming the rights in the character itself. And as rightly mentioned, the defendant or any other person is very well entitled to create their own characters or graphical representations of the public domain characters. But the blatant use of the characters from the game and just mere addition of designs in orbital decks does conclude to a copyright infringement by the defendants. Additionally, as to the human authorship, we follow the case of Noah versus Mazuma. In this case, the court had held that computer-generated artistic works shown as a part of video game, which are created by a software code or computer-generated code, are works of authorship of a person who devises the rules and logic, that is software code, towards the generation of such artistic works. And while we mentioned that Ms. Bonnie's engagement was on a work-for-hire basis, accordingly, anything created during her employment in relation to the materials was owned by Midnight Dive. Lastly, we do not concede that the NPCs are stock characters. As we already mentioned, under the Walt Disney Productions and Air Pirates, it is well established that visually depicted fictional characters receive independent copyright, and these are not mere stock characters. NPCs are original creations by Midnight Dive and contain Midnight Dive's artistic style. To be in all honesty, Your Honors, the fact that even if I show my little nephew, an NPC for a PUBG game, he would understand that this is from PUBG, and that's where the originality lies. And that's why it's not a stock character. I would like to now pass on the floor to Mr. Avi Bhandari.
Yes, Your Honors.
I'm sorry if I may just interrupt you. I think that rebuttal may be only presented by one person from your team.
No, yeah.
Am I not right, Sergey?
Yeah, we'll be distributing the time amongst ourselves. We'll be concluding in 5 minutes only. Your Lordship, Your Honors, the defendant had stated that while seeing World of Warcraft and Hearthstone, they will see that it is coming from Activision. But there's one missing part here, which is that in 2006, Activision had granted a license to Upper Deck Entertainment to come up with a card game based on the characters of World of Warcraft. And this license was then cancelled in 2010. So therefore, that game came from Upper Deck Entertainment. So this shows these are the rights of a right holder to license its rights to some other entity to prepare a card game. Secondly, the claimant has failed to prove any artistic relevance. Third, the decision in Metabuckins, there is no decision yet, and the facts of that case are comparatively different from these factors, because in that case, the artist had exercised an artistic choice. However, in this case, there is no artistic choice whatsoever. And lastly, what I would say is that the marks, it's a cardinal principle of trademark law that the marks have to be seen as a whole. And we are not claiming rights only in the work orbital. We are claiming rights in orbital harbor as a whole and orbital decks. And that's why we're stating that there is a similarity between the two marks. And in the absence of any artistic relevance, the defendant must be stopped. Otherwise, this new frontier of NFTs will become a playground for infringers to usurp on the goodwill of famous brands. I'll pass on the floor to my co-counsel.
I think you are running out of time, and as I understand, there is no right to extend the time for the rebuttal. I'm sorry for that.
Thank you, Your Honor.
Okay, may I ask the respondent, would you like to take your time for a sub-rebuttal?
Yes, thank you, Your Honor. Starting with the first argument, that we falsely claim that we do not extract the assets. The paragraph to mention is on the problem, not on the given timeline that specifically mentions all of the relevant information. Then on the control of the work of Anne Bonny, what is important to remember is that it's essential that the work is stored in company material, which is not the case here. And it was outside of her scope of work, as already proven. She was a server engineer, and this task of improving the user experience was not within her tasks. Then on the human authorship, it is indeed a burden of the claimant to prove originality and copyrightability of the assets. And again, they only mention a case. They do not prove how the case applies to their assets, how Brainy Brain is indeed, the assets created by Brainy Brain are the work of human authorship, what type of work their employee were doing. Nothing was given to prove that. So the court should consider that the human authorship was not proven. Again, they do not give explanation why it's original. They simply say that they are not stock characters because we can not consider them stock characters. I would like also to clarify on the Activision point. It was to only prove that since the players extract the assets from Orbital Arbor, and they were doing that before the creation of Orbital Dex, they know where the assets come from. And they also know that the cards game is not the same from the same company as Orbital Arbor. And one of the many elements to prove that is that the game is not launched via the same launcher. And finally, on the artistic relevance and the use of Rainbow's trademark, Rainbow's trademark is only used because the avatars and the NPCs wears them. It's not to take the brand and then use it directly in the card and then give the card as an NFT. So this should also be considered by the court. And that is my final sentence. Thank you.
Thank you. The pleading has been completed. Thank you very much for your participants and for your voices. It's now time for the deliberation. So as I understand, and Sergey, please correct me if I'm wrong, the teams will be now put in the waiting room and the judges will deliberate.
Minagus is going to move the teams to the waiting room and then we can begin discussions. You can begin discussions. Me and Tamara are purely to assist with the schedule.
I assume we're going to stop recording as well?
We will not, but this is not going to go public. It's going to be cutouts. We had the same thing with the semifinals. Okay, one more team member to go and then we can start. Okay, so you guys go ahead, and then me and Tamara are here to just provide some, protocol thinking.
I'm going to take a 30-second protocol break myself. I'll be right.
Sergey, just on the procedural side, I read the terms of these the rules of the pleadings, and that's why the reason why I said that only one person can present rebuttal. I thought it's still, it's still binding. This term.
I think, I relied on the experience that we had in the semifinals, where they all split 5 minutes.
Okay.
And actually, one team failed for a similar reason that the guys ran over time here, is that they said, oh, the three of us are going to do it.
Okay.
But in fact, one team member took out the chunk of the time, and then they were rushing and rushing and rushing. And you can see that there, come on, guys, have a better coordination. But in that case, they also explained to us that they were sitting in 3 different cities. So not in one room like these guys at Queen Mary right now. I actually managed to place them, line up them on Zoom so I could see the whole picture. Like this guy is in the middle, and then you could see a bit of an elbow from the other guy. So.
And Tamara, I can see
that was our mistake.
Support there.
Yes, sorry for this. Say hi. No, you don't see her anyway. So Anna, as to your question, indeed, according to the rules, one person should present the card. But okay, since we made this exception back in the semifinals, I think it's fine personally. So yeah, but it's up
and
to
they
you.
they kind of reaped what they sowed anyway, because they did run out of time. So
yeah.
Yes.
Okay, my dear judges from panel, who do you think should win?
I mean,
That's
personally, I think the claimant did a better job, all in all. But I also think it was a Herculean effort for one person to take on the respondent role against 3 people. So, you know, I lean towards giving higher marks, not overall, but, you know, I probably would give higher marks to the respondent than maybe her argument was worth, just because of like the obvious effort and you know, knowledge that she brought to bear. But personally, I think the claimants were superior in both their like style and the arguments they raised.
Konstantin, do you agree?
Yeah, I do agree with what Sean said. However, I think we all agree that also the claimants had strong and weak moments in their pleadings. A difficult one. I would have loved to see the defendant to focus more on the strong issues and not to be
cherry picked.
Yeah. So
yeah, I felt the same thing. I felt like she was trying to hit everything as opposed to being like, here are the 5 things that are most important. Yeah.
The other thing that was obvious with the defendant's presentation was that, you know, my understanding is that these pleadings were not drafted in response to the actual claimants that were here. They were drafted to another set of claimants, but she kind of followed the game plan of what she was responding to the original set of claimants very, very closely. And they had raised points that I think she didn't address until the rebuttal. You know, it is interesting to me that there's a factual dispute about who extracted the tools or not. I don't know that that matters very much at the end of the day, but had each party been listening to each other, you know, the claimant didn't have that opportunity before they presented. But I didn't get the sense because like it was actually harder to follow the claimants if you were just looking at the pleadings. I had the pleadings up on the screen. It was actually harder to follow them because they had evolved, I guess, over the course of the competition, what it was they were saying in their claims. Whereas I didn't see that with the defendant. I was actually able to follow in the pleadings almost word for word with just a few skips, exactly what she was going to plead.
Yeah.
Well, on my side, I really liked her arguments. I mean, I was like thinking, like, you know, before we started, we were asking ourselves, like, are claimants in the better position? And my answer was also yes. And I really like the arguments that she managed to think of, and specifically that she was working on her own. And I also really liked the way she presented that, even though, you know, sometimes we got bored a little bit by all that being, you know, provided one by one. But then I think she also was creating some facts that I could not really check in the, you know, in the factual scenario. So I think she just, you know, made up something just to make sure that her arguments are stronger by that. And, you know, if we are just not judging the, you know, the way she used the arguments, but we're also judging whether she, you know, she stick to the facts and used the law properly, then I would say this is something that was on her side weaker compared to the claimants. So, you know, on the side of claimants, I liked this second Juan Alberto, this person, the way he presented, you know, it was pretty convincing, and he was using different intonation, etc. So he was drawing my attention, and that was really professional. So I really like that. The other guys, you know, they were still fighting with stress, even though I thought that, you know, after semifinals, it will be much easier for them, but not with this, you know, wonderful
well,
team
the final
of
one
judges in front of them.
I don't know if it's just my Canadian senses or not. The final one in particular came across as like almost too energized and too fighting. It was like, I was like, oh, settle down. Abby.
No, he should have said sorry. Sorry.
And, you know, all the time I was checking, you know, myself being this awful judge who asks all these, you know, terrible questions. And they all, I mean, all on both sides, claimants and defendant, they all, you know, managed to stand it and to answer them, even though, the, you know, some questions were really difficult. So, you know, on my side, it's like, you know, I like them both teams to win. but I would just agree with you that most probably the claimants should win.
Yeah.
And then I guess, so procedurally, do we have to I mean, the claimant, I guess, raises a point about who owns the copyright and whether there's infringement and a number of things. Like, how do we make that decision? Like, because I'm not sure that they made out all their claims. I think on the whole, they would definitely have sustain some claim of action against her, but I don't know if it's all the claims or not.
I don't think, I mean, Sergey, please jump in. I know in previous times, we didn't actually kind of go through and say who we thought like won each issue. It was really just.
No, it doesn't matter. It doesn't really matter. I mean, what matters is that you look at the teams and you look at the people and you think whether or not you want them to represent you, whether or not it's a different case. I mean, it will be a different case, in a different court. So it's much more important to see how they react and how they can think and how they respond. For you, some facts. You guys asked a total of 20 questions in the current session. In the previous semifinal, there was 23 questions asked. That was George, Andy, and Katja. And in the first semifinal, it was 12 questions. So
I tried to rein myself in because I know last year they thought I was the mean judge.
We still think you're the mean judge. No,
this is what I thought, Sean.
Yeah, but yeah, I mean, to be clear, Laura already had the comments that one of you guys raised that you shouldn't try to cover every issue. You should just focus on the strong points and just go deep. So I think it's the same as the last year with the Polish team, where after the semifinals, the Polish team was told clearly by Jennifer, like, don't use the reference to the book. It sounds weak. And there we go to the final. And they're like, well, about the book. And I'm like, oh man, I mean, I understand you guys are all like wired up, but being able to sort of digest the feedback and then use it is one of the features. So I wasn't really feeling sorry that they got the second place in the first place last year. So that was like totally covered for sure. And then timing wise, the Piskin Karis team had the same situation when they were in the semifinal. For some reason, Abhinav took the chunk of time, and then Juan took less, and then progressively Avi took even less. I don't know what the setup is. I don't know who is like, what is the split of the roles or something. Juan actually won the best star list. We will announce it later tonight based on the ratings of all the like people on the team. And if you thought Avi was intense, you should have listened to the Malaysian team, where Mr. Minhua was like literally like right in your screen, telling things, and you were like, yes, I want it to be over. I agree. I give you whatever you need. Yeah. So he was like really passionate, but in a good way. Like everyone loved him, but sometimes he lost thread of thought, and then you were like, okay, this is not like reason and passion. This is just passion running ahead of the reason, and the reason is like catching up a little bit. Yeah, but all I can say, I mean, you're all seem in agreement. So creating facts, sure, is not something you want the console to do. Rigid structure and missing the points and the chance to respond, sure, that's like, that's a penalty. And then like, on the claimant side, sure, putting more effort.
I guess my feedback, my specific feedback to Laura would have been that I'm sure that the response that she gave in writing was very responsive to the claimants she had. But she had, 45 minutes to listen to what the claimants were saying in this case and respond to that.
I noticed that too, Ryan. Her whole thing was like, she did not really respond to anything that they raised.
And even out of order, she said she even opened by saying, I'm going to do it in a different order than what they did. It's like, well, but why? Like, why not address their most strongest point? And
yeah, and with respect to the knowledge of the law, she was, this at least how I feel about it, particularly weak on the NFT part, right? So her arguments were not really convincing. Her technical understanding was not right. So unfortunately,
I didn't get the whole argument that like no violation if you create an NFT against like the underlying copyright. I was like, huh? Like,
I even fed in the questions of the other side. I even fed her what she could use. I kind of did that. I actually thought that she would raise some of the things that we raised in our questions as points. Didn't go there. So.
I think it also has to do with the tone or something. I'm pretty sure she was reading most of the stuff that she was presenting.
Yes.
And then after the first few minutes, the tone became very much the same. It was kind of difficult to listen to. Well, like after a certain point, I don't know. I think Tamara had the same issue that she was struggling to comprehend.
Yeah, to be honest, I don't know. I struggled, and then I just lost it. So I cannot comment, and I couldn't comment on
on the substance. Sure. So it's up to you guys.
What about your partner, Tamara? What did she think?
Who's the winner? One or two? Один или два? She's saying the second one, so that's her opinion.
Hey, it can't be a unanimous court always.
So the process is like this. If you guys think you have a decision, then we bring everyone back in, announce the decision, and then we give them feedback. And for that, I think the easiest thing, I think the easiest thing will be to give the feedback first to the Pisk and Karis team, and then send them off, bring back Laura, give her the feedback, and that's it. So that's like a 5 minutes feedback they can take to improve their life in the future outside of this, moot court and everything.
Okay. So who's announcing the results? Is it you, Sergey?
No, you for sure. I'm just the timekeeper. So you will be announcing the results and saying that. I don't know.
Is there
like Connie was against, but we all voted for you or something.
Okay. Is there suspension time, drums, whatever?
No, nothing.
No,
it's the special thing is that we're gonna send the newsletter and do the LinkedIn post tonight and send them whatever attention they need and that they can use. And that's it. We agreed that it's much better for them to if Canon sees the fact that there is a Peruvian council looking for work and gets them to work.
So then we announced that the winner is the Pisker and Karis, then comes the Bravo, and then we say that we will now give them the feedback, but then we just wait until one side is moved
until Laura goes to waiting room. Yes, give the feedback to these guys and I will also I will ask them why Abhinav is getting half of all the time if you're 3 people. I don't know, man. I want to know.
Okay, guys, who wants to give the feedback to our teams?
I think everyone will just chip
in.
And,
everyone? Okay.
Everyone just
throw a stone. Yeah, all Americans are always begin with your English was great for someone who's not an English speaker. It was amazing. And yeah.
Was that your American accent?
I'm not gonna say that. Yeah. I'm gonna be Australian and be like, you guys all suck, and you need to take better English classes, or else I won't do this again.
Yes, we had.
Workers are mean.
We had one member of the team in the semifinals who had pretty hardcore accent, and also some echo in the room. So I was thinking, he's killing himself. I mean, it doesn't matter how strong the arguments are. It's just so difficult to listen. And then in the feedback session, the judges begin by saying, "Oh, your English is great. You guys are doing great." I'm like, "Oh man!" Like the next session, he will do the same thing and no changes. Yeah. Okay, Minduge. Let's please bring in both teams, and then Anna will announce the decision. So if you want to stream, we should stream.
So I think we have all the participants. Once again, thank you very much for taking part in this competition. We think you all did real well. But unfortunately, as in every type of competition, we had to make this tough decision, who wins. And it wasn't that easy to make this decision, but finally, we agreed that the winner of this year's challenge is Piska and Karis. Congratulations.
Thank you, Your Honors.
So much.
Thank you.
So what we're gonna do now is within like, I don't know, 10, 15 minutes after this, we will post the results and we will send out a newsletter with the results. So you may want to wait until then to announce so you can link to the whole thing. Now we will give some brief feedback, which hopefully will help you to be better, I don't know, lawyers. I wouldn't say better men, I would say just like better lawyers. So maybe argue more successfully. So we will begin by, Indigo, if you could put Laura into the waiting room, and then we'll give the feedback to Piscarius, and then we'll bring Laura back and give the feedback. Okay, so I'll throw the first ball. I'll just say, for some reason, you guys were not really good with keeping the time. The fact that out of 5 minutes in the rebuttal, Abhinav was speaking for 3 minutes, 34 seconds is pretty amazing. I mean, it's like, and you're in the same room, so you guys could have kicked him under the table and said, hey, man, and the same for the main pleading. I don't know how this is structured, but you had half of the time for Abhinav, and then less time for Juan. And then Avi was like rushing at the gunpoint. And I saw you do more steady in the semifinal, but today you came across as someone who like really had too much coffee and you were just going forward there. So I think like timing is an issue.
I'll say something as well. And this is, I think, something endemic to every kind of young lawyer, and when they're first getting out and arguing these things, is that you have to realize some of your arguments suck, and that not you, just in every case, there's always arguments that are not good, and it doesn't matter how you portray them. The facts don't back you up, the law doesn't back you up. And there's certain times where you have to basically let them go for the sake of winning a more important argument. Like you can't try to win. This is not a situation where you win because of the number of arguments you make. You win because you make the right few arguments. And in the balance of things, the judges look at that and they say, you know what? The arguments that they won were really the important ones. So my advice to the three of you is that you need to realize that, and you need to basically give it up sometimes. And I think that'll also help with your timing going forward when you realize there's probably 3 arguments that you really needed to focus on, and some of the other ones you could kind of be like, you know what, we may still win them or maybe we won't, but it doesn't matter if we win these other 3.
And very much related to what Sean just said, maybe one thing is to explain the legal background of an issue. The other thing is really to apply it on your specific case. So for example, in your pleadings, when you think about the part when you spoke about derivative works, this is probably one of the most difficult issues in copyright law, right? And you can speak very long about the legal background. But for you in your pleadings, it's decisive to apply all of that and to find the right 2 or 3 arguments, as Sean just said, to convince the judges. And maybe you want to focus next time for really to put your strongest argument first and really to focus on that, and then you can build on that. That's more convincing than arguing and losing a bit the path going forward. Yeah.
I think that's right, and I think that where that really came through. I mean, the first time you truly had a chance to respond to the defendant here was in your rebuttal, and it was like a hit this, hit this, hit this, hit this. It was like jumping from point to point to point. Honestly, you guys had picked 2 of the least favorite things that she'd said and just responded to those and really hammered on just how wrong that was. It would have been more effective than spending 10 seconds on this thing she said and 5 seconds on this thing and 20 seconds on this thing. It was hard to follow, but it also just seemed scattershot. I think you can really drill in issues a lot more than you did. Avi, I really appreciated the energy that you brought to your conversation. But when you were running through, I think you were, and my apologies if I got this the wrong order, but when you're running through the NFT explanation, was that
one?
That was one?
NFT explanations with regards to the Benbow trademarks, but with regards to the copyright infringement, it was Juan.
No, I think explaining the technicality of NFTs, was that one? Okay.
Yeah,
sorry for that. My notes are a bit scattered, but that was a classic example where, like, NFTs, you can go down a rabbit hole explaining how they work for a very long time. I think all that was really important to do was to establish why it was we were talking about NFTs, and then really hammer home how it strained your argument. I think because it was such a technical topic, I actually was thinking about the things you said when you were explaining NFTs while you went on to explain how it applied to your case, because I was still figuring out what it was you were trying to say. So, try and keep it simple when you're leading. Facts should be simple, and then arguments should be the strong point. That's my personal view.
And if I may adjust, anything to what our judges said, because I totally agree with what they said so far. In the end of the day, in the court, it's a matter on, how you behave and how we buy you, as, for example, as judges, right? Because they also buy you as personalities, right? And they need to, trust you during this very short time that you have to convince them to your arguments. And they already have your arguments in your writing. And then you just as our judges said, you just have to convince them by choosing the most interesting, most powerful arguments that you have, so that it stays in their heads. And today, during these finals, you presented some, characteristics, some elements that were really convincing to us, and which actually made you warm. Yes, like Abhinav, you have this really nice way of using case studies, right? You've been doing that really greatly, and I was impressed by the way how you could, just give us examples whenever you needed to back up your arguments, which was very good. Juan Alberto, you are very convincing when you're speaking. You've got a good pace of speaking. You are just, the tempo and the way of how you're underlining your arguments, the way how you're doing that. This is convincing. This is the way how we would like to listen to that, instead of, just listening to somebody who's like reading something. And whenever anybody is reading something, after 30 minutes, everybody gets bored, right? So this is the type of reaction that we needed from you. And on the side of Avi, I really like the way how you reacted to our questions. Our questions were, I understand, not very nice. Sorry for that. That was on purpose. I hope you will not remember us for that. But this is actually what gives us the idea on how good litigation lawyer you will be in future, because you will be able to react that nicely and so much in a professional style in the court, when you'll be asked all these tough questions from judge who doesn't have an idea of what you're talking about, but he's asking his questions because he has his agenda, right? So all three of you did that really great, and we were impressed by that.
If I may just add one quick thing to what Anna just said, I agree. Handling of the questions was wonderful, and one thing that you guys should look to identify kind of going forward is when the questions are being set up by a judge to help you versus to hurt you, because there were a couple of questions basically that were thrown in by different judges that kind of helped allow you to get a point forward. And it's always important to realize that when someone's asking you that sort of question, because ultimately you may not win because the judge could be doing it for a different reason. As Anna just said, they have their own agendas, but definitely take the opportunities when those softballs are pitched to you to knock them out of the park, because that can only help you.
I would also say that what you guys are saying also applies not only to the court, but to the summit. In the past, we had very extensive presentations by people who crammed everything about their region, and it was very hard to listen. In particular, I think there was one presentation about Poland where I think in 20 minutes, we got everything there is to know about the Polish law, and no one could remember anything. And then you have presentations from people from, Switzerland or Canada, and they basically say, here's the 3 things you need to know, or here's, 3 things about Brazil that you need to know. And it's exactly how all the councils think. They don't really want to study in depth the whole country. They just want to know these things, and then that sticks, and then also responding to the audience. So, when Connie is on stage and he's looking at the people and the people are asking questions, he's adjusting his presentations to the people that are in front of him. And then when we have some, let's say, junior lawyer coming in and they're so stressed that they just throw it out, done with it. Yes. But the thing is okay, man, I could have read a book. Why would I sit and listen and watch your presentation? So in the same sense, your performance, you will see it also at the summit. So you will be able to follow and adjust. Tamara, anything else from your side? You're impressed?
Guys, you were great. I'm impressed. Everybody was great. So congratulations.
If I may just say one last thing, at least on behalf of myself and I know the other judges, we hope to see you guys at the summit, and please come up to us and badger us with questions, and connect with us, between now and the summit or just at the summit. So.
And provide us your feedback, like, hey, your resting face is really mean. It was really hard to talk to you, or whatever. Give us that feedback too.
I've already been told last year I was the mean judge, so I hope I actually hope I'm not this year. I think it was Ryan this year.
Congratulations, well done, really good.
Thank you.
Great. Thanks guys a lot. And for those of you who need the visas, let's start on the visas. There's 4 months left, so who knows what's happening. So let's get started on this. Thanks a lot. Mindaugai, I think we're ready for the swap.
I just want to say, I'll let Gaetano know he earned 20 pounds.
I mean, they change rates, anything could change between now and the 4 months. But Gaetano will be so happy. I am also so happy for him that this is the year when his team goes up, and there's a number of people who went to Queen Mary at the summits. For example, Alexandros Alexandrou, who did the case, and he's now with Tamara, but he's coming from Queen Mary. So yeah, I'm sure they all will be proud of you. And you have to find some kind of a bottle of beer, throw out the beer, put in some water, and then use it to go around, because otherwise I'm not responsible for when do you show up on the second day.
Yes.
Okay, great.
Thank you so much.
Mindaugai, let's do it.
By the way, Sergey, I don't know if you noticed this year, DICE Europe is like a couple days before the summit.
Oh.
But
no idea.
Not the same. I'm actually thinking I'll do both. I'll come and do Barcelona and then fly over to Lithuania.
So it's a DICE Barcelona gate. So they're in Barcelona.
It's DICE Barcelona, and it actually kind of works perfectly. It ends kind of like the day before we would fly basically to Vilnius.
At some point we just gave up on tracking the changes, because a lot of conferences keep moving things around, but yeah, now we need to think whether or not we want to do something in Bilbao, because a very, very good friend of mine is now the director of the games festival there, and the festival used to be called Fun and Serious Bilbao. Bilbao is an amazing place, gastronomically, culturally, visually, it's so. Okay.
I don't even know what country.
Awesome. Well, I mean, let me start by saying that it's a city with a river that goes. Oh, we need Ryan Mindaugai. He got booted, so we need Ryan, please, back. It's the city that has the river that goes one way in the morning and the other way in the evening. And you can have wild mussels brought to your table where you grill them over the coals and I mean, there's so many things, so many good things about Bilbao, okay, except for the weather. But the conference used to be called Fun and Serious, which is a really strange thing going back years ago when they had serious games part and the like non-serious. So I told my friend that, you know, next time I will come is when you will change the name. So he became the director and he changed the name. Now it's called Bilbao International Games Festival and it's in December. So we are talking to Andy Ramos about whether or not we can involve more Spanish law firms. Minugas. He got booted. He thinks he got booted because he was the meanest judge. I don't know if. So same link, right?
Sean, be careful. It could happen to you as well.
Wouldn't be the first time.
Okay, he should be rejoining. Yeah. So we're looking into whether or not we can make it into like a 20-30 people event with entertainment lawyers from Spain, presenting to all of us what's going on in Spain, and then having a nice dinner, and then maybe having like 10-12 speakers, and then a bunch of younger lawyers from Spain attending it. Obviously, I mean, over the next months we have to look at this. I don't know.
We also have an entertainment law program.
Tamara, hard to hear you.
Okay, whatever.
It's a different microphone, I think, than the computer.
Yes, I switched off my headphones. No, I was saying that they have an entertainment law program in the. Wait. Now. Good now? No. Okay. I was saying that they have an entertainment law program at the University of Deusto, which is in Bilbao. So we can also think about expanding this to the young lawyers kind of like graduating from this program. I heard it's good. I actually graduated myself at the University of Deusto, but not from this program.
Just, you know, tomorrow we're losing you again.
Yeah.
Yeah.
Okay, sorry. Okay, forget about it. Let's get Ryan back.
Now we hear you. I just sent him the link. I said he should come back. I sent him the invitation link. Sorry about this, Laura. We are like in the middle of the logistical thing, waiting for Ryan to come in. First of all, before they all like start to criticize you, let me say that you've done a great job being in 3 roles and taking the whole thing alone. That's a huge chunk of work. And you know, Tamara and me were defending you against all the other judges, but we couldn't overwhelm them. So, you know, they made the decision. And I think we can start with the feedback, and then Brian should be able to click on the link. He just sent me something.
Laura, congratulations. I think your task was really tough. I mean, to defend this case by yourself, prepare all the arguments, and then, you know, to react in such a structured way. And this is something that I was really impressed with. That you've came up with so many arguments, which we thought that it was not that easy to think of. So we were really impressed by that, and I think, you know, this is actually what made us think strongly on who should win this case, this competition, because this was really your strong point. I'm sure my colleagues will add in a moment to what I say, but what we would like to let you know as feedback is that even though your arguments were very, very strong, we thought that if you could just focus on the most important ones and convince us to them, it will have much more power compared to what you did. I mean, you wanted to tell us everything, which is, of course, not a bad thing. It's just that when you're already in front of the judges, you still need to take into account that they are people, right? So they lose their attention very quickly. You need to drag their attention. It's, you know, I would compare it to kind of a show, you know, that you need to make in order to make sure that they stay with you, that you are convincing them. But I also before I say everything, sorry guys, but I will just stop in a minute. But I just also want to add that I really like your professional style. You are so patient in terms of all these, odd questions that we asked you, and you responded to all of them, and you did not lose your track, which was really impressive. And this is also something that makes a good litigation lawyer. But now, guys, I will also give you the floor. Sorry.
To jump on that a little bit, and I agree with what Anna said, and I think, I was chatting with Sergey at one point, being like, "Is she arguing everything herself?" And I'm like, "That's amazing." But there is something to be said with not sticking so much to your script, and I think one of the points that happens when you're in front of any sort of panel is that they ask you questions that lead you off of maybe what your master plan was. And you always have to have that master plan so that you can go back to it. But it's one of those things where you need to have the flexibility to basically branch off, even if you're like, well, I was going to get to that in 5 minutes. Let me do it now. And then be able to do that with the flexibility, then move back on and realize that, you covered that, so you don't need to go back to it. So that was, in my mind, that was probably, one area that, I think, you could have done a little bit better. You were good with it, but I think you kind of could have done that a little bit better. Secondarily, it was obvious that you had your arguments in place and you had what you wanted to say, and I think that's so important. But the claimant spoke for 45 minutes, and it kind of was apparent to me that you didn't really modify your argument to respond in a way to theirs. I mean, the good point to being the respondent is you actually can redesign the flow of your position based on either strengths or weaknesses in the claimant's role. I mean, in the claimant's argument. And I think that would have been something that elevated your argument up to like the next level. But again, I think everything you did was amazing, and I give you all the wonderful lauds for having like written everything and argued it all against 3 people. So.
Yeah, I fully agree with that, Laura, and congratulations. You did a wonderful job. And I think what Anna and Sean just said is really what you can be proud on. I think your participation in this year's session is a fantastic basis to take the next step. And we can all see that you will be a rockstar lawyer. You have everything to fulfill the last bits and pieces to win such a competition. That was just wonderful. Just to add to all the points that were rightfully said already, there was one part in your pleadings where you lost me a little bit when you spoke about the NFT part. There I had the impression if you develop your arguments more step by step, that would have been a bit more convincing. Sometimes I found it, in particular with respect to this part, I found it a bit difficult to follow you in that regard. So it's absolutely right to focus on what Sean and Anna just said, to focus on the most decisive arguments and also to shorten things and not to lay down all arguments you have. But if you have the feeling that there's a particularly important aspect, develop your arguments thoughtfully, step by step, and then they will come across more convincingly. But overall, well done and super job, really good.
Do you have any questions to us?
I wanted to thank you for the kind words and advice. Yes, indeed, I actually tried to not read the script because it's something that the other judges already said to me. And I tried to do that by skipping some part and saying, as already stated. Wait. And for the redesign, I tried in the examples they were given, like League of Legends and World of Warcraft, but it's true that it was not always on the legal arguments themselves. And yes, indeed, for the NFT ownership, I took a certain direction, because in the case, the action was on the NFT trading. And so I wanted to differentiate the NFT trading as ownership and copyright. But yes, indeed, that needed more information, more detail in order to be better understood.
Well, and kind of on following back to what we said before, on some of those issues, there are times where, as an advocate, you need to basically be like, this one's a loser, and just let it go, because it's going to take up time, and there are other arguments that you had that were much stronger, and so I always tell everybody, like, realize when it's a loser and move on, because unless it's a core argument for your entire case, like, just let it go.
Thank you.
I think everyone said everything. I have my notes, but yeah, I don't think anyone forgot anything to say. At the beginning, it was really easy to listen to you. A bit later, it became a bit, maybe you got tired, maybe you were reading into it too much, but it was progressively harder to focus on what you were saying. So in that sense, the other guys and the guys in the other semifinal that were going up and down, it was like watching a theater show. And it was entertaining just for the sake of it. Like, even if you disagree with the arguments, you can feel that the guys like, oh. At one point we had a team from Kiev, and one of them is now at Harvard. I think she graduates this year, and she's now with, is she with MSK now, Tamara? Yeah. Okay. She used to be
like a 1 year with MSK.
With Wargaming, and now she's with. Yeah. And her partner in the team is now with Playrix. He's the M&A counsel of Playrix. And if you would watch him play it, he was like, this is the end of the world, He would stand up and do this and do this and do this and do this, and then sit down and then get up again. But the thing is, everyone listened to him start to finish. Like, everyone was following this guy because he was so agitated, and they won. And he doesn't do this in real life. So I was wondering if he goes into a corporate development deal and does the same thing. We're gonna buy your studio. No, it's like, no, he doesn't. So yeah. So that'll be great. But you will see how people perform at the summit. It's a little bit similar in a nutshell, and we very much look forward to seeing you in September.
Definitely. Please come find all of us. So.
I just wanted to mention that Laura, by the way, is the only female participant. You can't hear me again. What's wrong?
I think, Tamara, you're saying
a little bit.
I think you're talking into a different microphone.
Okay, I don't know what's happening, but Laura is the only female participant and the only one-person team this year. So congrats to them.
Yeah, you did
Thank you.
But on the other side, there'll be a whole bunch of French lawyers this year. Like, it's if there's one region that keeps increasing every year, it's the French. And just from Ubisoft, we have 11 people coming from different offices, granted, not from Paris, but from the other places as well as from Canada. But they're all French speaking. And I was looking at the shit, and it's like 11 Ubisoft people, and all the names are French. And I was like, okay, we have more Spanish people coming as well. I think we have at least 5 this time. There's more people who are now working from Barcelona. There's one Spanish lawyer who is working from Paris, but she is Spanish as well. So we are like, this part of the world is growing. I think you'll meet some fun people there too.
I'm looking forward to the summit.
All right, guys.
So, congratulations once again.
And as we talked, Ryan made like 10 attempts to join. I keep seeing emails between him and Mindaugas, and Zoom doesn't want to let him in. So on his behalf, very sorry that he couldn't give feedback. Great. So I'll post the results in probably 10, 15 minutes, and then wish you all the best. And feel free to reach out to everyone, even ahead of the summit, if anything. Thank you very much.
Thank you.
Bye-bye.
Cheers.